Hi, everyone. This is Sam Silverman, Managing Partner of EB-5AN. Thank you for taking time to join us on today's webinar. Today, we're going to be speaking about adjusting status with an EB-5 investment, and also we'll discuss some recent EB-5 visa demand trends for both rural and urban TEA projects as well. So quick overview that we just talked about of what we're going to cover today. And to start, a little bit about EB-5AN. We're a leading EB-5 investment fund manager. We've helped over 2,000 families from more than 70 countries invest in EB-5 projects under our network of EB-5 regional centers. One thing that sets us apart in the industry is a commitment to 100% investment transparency. We make all of the offering documents and financial statements for our projects available for investors to review, so they have the complete set of available information available to them. Another thing that we really pride ourselves on is informational content. Our blog has hundreds of articles about how to diligence a project, what questions to ask about the immigration process, and about pros and cons of different investment structures, as well as an active YouTube channel with over 1,000 helpful videos on it as well. As I mentioned earlier, I'm Sam Silverman, one of the two managing partners of EB-5AN. A little bit more about my background and bio is there on the left-hand side, and my partner Mike Schoenfeld there on the right. Our company has a network of approved regional centers that cover the whole country, which means that we can actively look for the most compelling rural and urban EB-5 projects around the country, and we're not limited on any one geographic area. We've worked with many investors from around the world. This is a map showing where many of our prior clients have come from over the years. And our projects and information that we've put out has been featured by many of the leading publications as well. And now it's my pleasure to introduce our guest panelist, an experienced EB-5 immigration attorney, Dennis Tristani, also a fellow Yalie. And yeah, very excited to have Dennis with us. He's been in the EB-5 space for a very long time and has extensive experience, both in EB-5 and in other visa categories as well. And so I'll let Dennis jump in, introduce himself, and share a bit more about his experience as it pertains to EB-5.
Thanks, Sam. Nice to be with everyone again. Dennis Tristani, based out of Rockville, Maryland, just outside of Washington, D.C. I've been in the industry for about 12 years now. Founder, partner of Tristani Law. We're a EB-5 immigration law firm, business immigration law firm, generally specializing in EB-5 investments, both direct, regional center based, and all other temporary and permanent business visa solutions, green card solutions, and we also do family work as well. Always great to be here with EB-5 and Sam, so thank you very much for having me.
All right, perfect. All right, so the main topic we're going to discuss first is just adjusting status with an EB-5 investment. So, to start with, just at a very high level, for those of us who aren't immigration attorneys, what is adjustment of status, and how does that benefit kind of fit in with the EB-5 visa program, and how does it help clients, and who does it apply to? We'll get into those topics a little bit more, but maybe to start, just the broad overview, and then we'll touch on these 5 items first.
Yeah, sure. So generally speaking, when an individual files any immigrant petition, whether a family member sponsors you with an I-130 petition, your employer sponsors you with an I-140, or maybe you self-sponsor with like an EB-1A petition, or if you file an EB-5 petition for an an investment-based petition, there's essentially 2 ways for you to get your physical green card based on that immigrant petition, that EB petition. If you're outside the United States, once that petition is approved, assuming your priority date is current, you'll obtain an immigrant visa, your green card, and an embassy or consulate abroad. Okay. If you happen to be in the U.S. In a temporary non-immigrant status, you can file an application called Form I-485, which to adjust your status, essentially to change your status from your current non-immigrant status to green card while you're in the U.S. Okay, so you have to be physically present in the U.S. and a temporary visa status, such as perhaps H-1B or L-1, F-1, for example. Significant benefits to adjusting status. Most of my clients who want to adjust status are here. They don't want to have to go home to India or China or Europe, for example, wherever they live, to attend a consular interview, which takes time and is obviously very disruptive if you work or study in the U.S. So you change your status here. You adjust your status from that underlying temporary status to green card. Okay, and essentially that's the process where one obtains your green card based on that underlying petition you filed if you leave here in the U.S. If it's helpful, Sam, I can sort of run through these other points too, if that works.
Yep, let's do that.
So again, yeah, you don't have to go home. You can change your status here. And again, there's caveats there we can discuss later in terms of whether you can travel after you file adjustment of status, depending on what your underlying status is. One of the biggest benefits I'd say are the following. When you file for adjustment of status, you can also file 2 ancillary forms with that I-45 application. You're allowed to file Form I-765, which is a work authorization for an EAD card, and you get to file Form I-131, which is for advanced parole, essentially a travel permit. Okay, these are benefits specifically because you're filing to change your status, to adjust your status in the U.S. These benefits are not available if you're pursuing consular processing abroad. Okay. Second, when you file for adjustment of status, okay, that in and of itself, you could almost consider it a backup status. It's not a status, but if you were to drop out of your underlying status, right? If you lose your job, if your study time is running out and you're out of you're out of F1 status, if you have that pending adjustment of status, you can remain in the U.S. lawfully pursuant to the pending adjustment of status. It's a period of authorized stay. Okay, you can use the work permit, you can use the travel permit, and you can stay here indefinitely. Okay, until that green card arrives. Okay, so for clients, for a lot of my clients that may be in a position where their status is expiring, that's an incredible benefit. And obviously, the time in conditional green card status, if you're applying for EB-5 or any green card status that that may be, whether it's conditional or permanent, counts towards the 5-year requirement towards citizenship. So the moment you obtain a conditional green card, that starts the it's essentially a 5-year clock towards applying for naturalization.
All right, great. That's super helpful. All right, so let's talk about who's eligible and what really determines eligibility at a high level, and then let's go kind of category by category.
Sure. So yeah, you're eligible to adjust status, and there are all sorts of caveats and exceptions we could get into. I think at a high level, I think it's helpful to talk about these visa statuses, just because these are far and away the visa statuses that most people find themselves in if they're here in the U.S., either working, visiting, or studying. In order to adjust status, you have to be physically present. Okay, so you can't do so if you're outside the country. Even if you have a visa to come back to the country, you have to be physically present when the application's filed. Okay, so travel considerations, timing, very important. Okay, when we're looking to file for adjustment of status. Generally speaking, the first 2 categories, B1, B2, and F1 visas, many people have these visas. There are asterisks next to them for a specific reason. They are not dual intent visas. Okay, and what that means is the H-1B visa, the L-1 visa are dual intent visas. That means, in a paradoxical way, paradoxically, you can have the intent to stay in the U.S. and you can and have a green card petition filed on your behalf, and you can also have the intent to return home after your visa expires. Okay, B1 visas, F1 visas, and E2 visas to a certain extent are non-immigrant temporary visas that are not dual intent, which means when your stay expires pursuant to your I-94, okay, you're supposed to have the intent to return home, after your trip is finished, your studies are finished, or your investment time on an E2 visa is finished. Okay, that's relevant for the following reasons. Okay, if you find yourself in a situation where you've traveled to the U.S. recently on one of these visas, okay, for example, we'll use B2 and F1 for an example. The admission date's very important because every time you use your physical visa that's in your passport to re-enter the U.S., you create a new admission. You create a new I-94 record that is taken down by CPB when you arrive at the airport, and that record is permanently available and affixed on CPB's website and their database. Okay, it's advisable not to file for adjustment of status or take any action that essentially can be as misrepresenting your intent when you arrived on one of those visas after arriving. And typically, I won't get into the nuances of the old 60 to 90 day rule. That's changed somewhat in both the policy manual and the foreign affairs manual since. Generally speaking, you want to speak to your immigration attorney if you've recently traveled on a B1 visa or an F1 visa and you want to adjust status pursuant to EB-5 or any other immigrant visa. It's doable, okay, but there are certain circumstances and other issues you want to take into account, and generally speaking, you do not want to do so very soon after you've arrived on these visas, okay? H-1B and L-1 visas are the classic dual intent visas, okay? They were visa categories created a long time ago to facilitate employment by large multinational companies, the transfer of managers and executives from foreign companies to US companies. Many individuals in H-1B status or L-1 visa status may have a pending I-140, a pending immigrant petition from their employer that may be approved, okay? The fact that you can keep renewing the H and L visa while you have a pending or approved I-140 is because it's a dual intent visa, okay? When you factor in adjustment of status, what that means is there are no restrictions when you can apply for adjustment of status after a recent trip or a recent admission, okay? If you return to the US on day one on an H visa, you can turn around and file an I-526 and a concurrent adjustment of status application if you're in H or L status, because that is expressly permitted. They are dual intent visas, okay? The E2 visa is, a unique visa in the sense that it's a temporary investment visa. Many of my clients have them or in the US on them. I treat them similarly to any other non-immigrant visa simply because, they are not strictly dual intent visas. There is language in the policy manual and the foreign affairs manual that makes them a bit more flexible, a bit less rigid in terms of the non-immigrant intent one has on an E2 visa vis-a-vis, say, a tourist visa. Again, all that being said, depending on your status, you absolutely want to speak to your immigration attorney in terms of when it makes sense to file adjustment of status based on your current underlying status, okay?
All right, great. All right, so now that we've kind of got a feeling for what you can adjust from, let's zoom out a little bit and just kind of walk through what that whole process looks like in the context of an EB-5 investor, signing up for a project and kind of working their way through each of the immigration steps.
Sure. So let's see. Obviously, most of my clients, I think most attorneys would say the same thing in the sense that clients you'll start the EB-5 process doing a lot at once, right? You're looking at projects, you're evaluating which project you want to invest in, and in parallel, you're working with your immigration attorney on source of funds documentation and on filling out and completing the relevant forms that need to be filed. Okay, so in any concurrent filing, there's the underlying immigrant petition. So in this case, we're obviously talking about the I-526, which is for EB-5. Okay, the I-526E if you're going to a regional center. And then there's the I-45 application, which is to adjust status, again, to change your status while you're in the US from, say, H-1B to green card. The I-765 is your work authorization application, and the I-131 is a application for a travel benefit. And in this instance, it's advanced parole, okay, which you can think of as a travel permit of sorts, okay. All four of those forms are filed together, So if we're putting together an EB-5 sandwich, so to speak, you're going to have project documents, you're going to have subscription documents, which confirm you've invested, which confirm what project you've invested in, okay? You're going to have source of funds documents, which confirm where your EB-5 investment comes from. And then you're going to have forms, okay? Each of these forms, they're lengthy, and they request a specific benefit, okay? All 4 of these forms are filed together on the same day, okay? You could have a situation where you file the I-526E first, okay? Perhaps even when you were abroad, you happen to, come back to the US for work, and then you get the I-45, I-765, and I-131, and afterwards, once you have a receipt notice for the I-526E, that's also doable. But if you're in the US, you can file all 4 at once, okay? In terms of timing, which is always very imperfect in terms of how USCIS issues documents and receipt notices. You should get receipt notices for these 4 forms anywhere from 2 to 8 weeks after filing. Typically, the I-526E notice will come first. The other 3 notices will come together separately. It usually takes a bit longer, okay, depending on the service center that's processing those forms. The next relevant step, you should have a biometrics appointment before the work and travel permit are approved, unless USCIS is reusing previously captured biometrics, which could be possible. I-765, I-131 approval, I'm telling clients 4 to 6 months right now. About a year ago, it was about 2 to 3 months, okay? It really varies. A lot of my clients will ask, is there a way to sort of expedite the issuance of these documents? There's a formal process to do so. It's difficult, it's discretionary. You have to meet one of USCIS's expedite criteria, which typically involve, losing a job, financial loss to you and your family, or some other, significant life event or humanitarian issue that would require USCIS to expedite. Again, 4 to 6 months is what I'm currently seeing for most of my clients in terms of the issuance of these documents. We always ask for what's called a combo card. It means that you're going to get the work permit and travel authorization on one sort of credit card sized document. If you've had an EAD before, perhaps if you're in H4 status, if you've been an OPT, or if you've had STEM OPT, you'll have a similar document with just a different code, okay? Sometimes USCIS will issue the documents separately, okay? You'll get a work permit and you'll get a paper advance parole document, which is, a bit more cumbersome in terms of carrying it, but sometimes you'll get them separately. And if you get them separately, that frequently means they'll be issued at different times. It shouldn't be, months apart, but it may be a few weeks apart, okay? The EAD and travel permit are usually issued for 5 years. That's what I'm currently seeing. You could have a situation where the EAD is issued for 5 years and the advanced parole is issued for 1 or 2, okay? Generally speaking, there's no rhyme or reason. Mostly I'm seeing 5 years. Sometimes there may be a reason they're issuing it for less. I won't get into those particulars now, but generally speaking, 5 years, and they're renewable. They're renewable so long as the adjustment of status is pending, okay? Which is why it's such a significant benefit to get your adjustment of status in, because even in the event that your green card is going to take 2, 3, 4, 5, 10 years to approve, for example, and I'm just giving you a wide range, you can renew the work and travel permit for that whole period of time until you get your conditional green card, okay? So that's very attractive for individuals that may not have work authorization, that want to potentially quit their job and do something else, start their own business. There's a lot of flexibility there. Next relevant steps, after those 2 documents are approved, you're going to have the I-526E adjudicated and approved, okay? Again, that's project documents and source of funds documents, okay? The project documents are either pre-approved, right, if the project application was approved prior to your filing, or it's approved while your I-526E is pending, typically after the project application is approved, the 956F. The I-526E is approved, in batches months later, okay? General timelines, I'm seeing 8 to 12 months for rural cases, probably closer to a year and a half or longer for high unemployment cases. This is anecdotal. This is not anywhere on the website. That's just what I'm seeing. And again, processing times can vary significantly. Once the I-526E is approved, that puts the I-485 in a position to be adjudicated if your priority date is current based on the visa bulletin of that month when the approval happens, not when you filed. So just because you filed when the visa bulletin was current, that doesn't carry over 8 months, a year later, okay? It's what is visa availability when the relevant petition is approved. So if you consider your I-526E just like an I-140, your I-140 may be approved, but the visa bulletin isn't current. Same situation will apply in the I-526 context, okay? If the priority date is current, based on the visa bulletin the month that it was approved, your I-485 can be adjudicated, which typically takes anywhere from 3 to 8 weeks after approval of the 526, and your green card will be mailed to you, okay? Final step, is the 829. That has to be filed in the 90-day window from month 21 to 24 of the conditional green card. Okay, that's the removal of conditions. Relatively straightforward petition for a regional center investor. That's put together by your attorney and documentation that the regional center provides, updated project documentation. The filing of that application extends your conditional green card status indefinitely. You'll have a receipt notice that confirms a 4-year extension of the card, okay? Even if it took 4 years or more, you'd still have conditional green card status under the law, even if you didn't have a valid receipt notice. You'd want to get a passport stamp if it's taking more than 4 years to get your 829 approved, but I'm not seeing that with too many cases, and most clients will generally sue to get that approved earlier. That being said, the 829, once the 829 is approved, you'll have a permanent 10-year green card that's renewable indefinitely, depending on how long you've been a conditional resident for. Again, if it's more than 5 years, you can opt to file naturalization as soon as your 829 is approved. You could even file it before it's approved, but it won't be adjudicated until that 829 is approved.
Perfect. All right. Thank you, Dennis. All right, so now let's kind of look at these in order and just kind of go through how the timing of the investment overlaps with the EAD and then the green card.
Okay, it's a nice chart. So again, most of my clients are very concerned with timelines for all of these petitions and applications. I think majority of them want to know when they're going to get the work and travel authorization, especially if you're in student status, if you're in H-1B status and you don't have a pending or approved I-140, and so you're running out of H status, or you just want to not work for your current employer and do your own thing. EAD's incredibly flexible and important. This chart is very accurate. I'm really seeing 4 to 6 months for the EAD and travel permit. When they're bifurcated, when they're separated, and you don't get the combo card, I am seeing the EAD issued first. So again, if the EAD is issued in 4 months, I'm typically seeing the advance parole issued in maybe 4.5, 5 months. Sometimes one could take a lot longer than the other. 2-3 months, you may have cases that get mixed up or USCIS makes a mistake. You can always write to USCIS. You can create service requests. There's ways to push the envelope, so to speak, to get them to sort of do their job correctly. That being said, this chart's very accurate in terms of in what I'm seeing anecdotally with most of my clients. Every once in a while you'll get an EAD or advanced parole that just isn't adjudicated in that time frame. I've had a few clients get their green cards before they even got their EAD or advanced parole because they had a very quick I-526E adjudication, which again isn't a bad thing. It's just sometimes these things happen out of order.
All right, great. All right, so let's now shift the conversation a little bit and talk about some of the benefits. We kind of alluded to them a little bit earlier and why the timing is sensitive to when clients are going to get these. So what are the real benefits? And obviously these are going to come a lot quicker than green card benefits. And how do these benefits kind of compare, contrast with getting the actual green card?
Yeah, it's good, real good point. The EAD is an open work permit. So if you've had one before, the EAD, sometimes you'll have an EAD from OPT or STEM or some other, because you filed a different application. The EAD you'll get with adjustment of status is an open work permit, which means you can work for multiple employers, you can be self-employed, you can have part-time work, full-time work. It is open work authorization, okay? There are a multitude of benefits to having it in the sense that you're not tied to your H employer, your L employer, right? So for a lot of my clients, that's incredibly beneficial. Once you have an EAD, you'll be able to get an SSN, Social Security number, okay? Nowadays, it's your traditional brick and mortar banking and other, loan operators, if you're looking for a mortgage loan, et cetera, they want an SSN. They're not, there's very few banks that are going to provide you with credit opportunities if you don't have one, even if you just have a tax ID number. Most larger ones are going to want that SSN. When you apply for an EAD, you can ask for an SSN if you don't have one already. Okay, you don't need two. You can keep the one you have if you've had an EAD beforehand, or if you have work authorization, which is what you need to have an SSN. And so, there's in terms of work authorization, right? There's not a huge difference between an EAD and a green card. Certain employers, government employers, other, depending on who you're working for, may require you to have a green card, even citizenship. I think that's a pretty nuanced issue, but depends on your employer and what they may require based on who they are. But all that being said, it's an open work permit, so you're going to have the same benefits in terms of being able to work for multiple employers or yourself, which is akin to having that type of work authorization under a green card. Advanced parole is it's essentially travel authorization. It's not a visa. What I always tell my clients, it's when you travel on advanced parole, you're requesting to be paroled back into the U.S., right? It's not, you're never 100% guaranteed to be admitted. Now, that being said, when you arrive at an airport and present advanced parole, you'll be put into secondary inspection, which is completely normal. It's because the officer has to make sure your adjustment of status is pending, okay? And so if you ever traveled using advanced parole, your attorney will walk you through what to typically expect and what documents to travel with, but, you shouldn't have an issue. It's not authorization to remain outside the U.S. for years and years. Okay, that's not what that's not what it. You could have the argument that would be misusing it. Okay, but it is travel authorization that is a specific benefit to having a pending adjustment of status to give someone flexibility to re-enter the U.S. if they don't have a valid visa or if their visa is expired. Okay, so for some of my clients that may have an expired H visa, L visa, if you've done visa stamping in India recently or a few other countries, it's taking a long time. It can be a pain. Sometimes your stamping can go awry for some reason. You can be put into admin processing, and they can delay your ability to return to the U.S. and work or see your family. And so advanced parole's, very beneficial in that sense if you are in that type of situation. Okay, if your visa is expiring, you don't want to renew it, you can use advanced parole. I always recommend, use your current visa, stay in your current status. If that makes sense, that's the most conservative thing to do. But advanced parole is it's a nice travel benefit, and there's a lot of flexibility there. One thing I would note is that when you file for adjustment of status and you also file for advanced parole, you generally want to wait to travel until you get that advanced parole document, okay? And the reason being is if you travel before the advanced parole is issued, or if you don't have a valid advanced parole already, if you've been through renewals, USCIS can deem your I-131 abandoned, okay? That's even in the case if you're in H or L status, you travel quickly, your adjustment isn't abandoned, your work permit's fine, your I-131 may be abandoned, okay? That's current USCIS policy. Doesn't always happen. Sometimes they still issue it, but they should catch your travel. And if that's the case, when you return, you just reapply for your advanced parole. Okay, so something to take into account. I always say talk to your attorneys about travel. It's always very important, what upcoming trips you have. But yeah, that's generally the rule.
Okay, great. Thank you, Dennis. All right, so a common question that we often get is, well, what happens with my child if they're close to 21, but I apply now? and then there's a backlog in the future. How does that work? And is my child still going to be protected and be able to get the green card along with me and my spouse, and not risk having an age out issue? How does that kind of work with EB-5?
Yeah. So we could have a whole webinar on the CSPA. So I'll try to keep this as sort of simple and as straightforward as I can. And Sam, do let me know if I'm talking too much or running over here. But so Child Status Protection Act, it was God, it's at least 20 years old now, probably more. Essentially, it was created to help protect children who are close to 21. You have to be under 21 to immigrate with your family. That's the definition of a child under U.S. immigration law. And it was essentially, the act was passed to keep families together in immigrant petitions, both family and work petitions, but for USCIS taking too long to adjudicate a case. So what the CSPA essentially does is when you file an immigrant petition, okay, say it's an I-526E petition and you're a family of 3 and your child's 19, okay, the child's age is frozen temporarily, okay, upon filing. What that means is your child's age for immigration purposes does not go up. It's frozen the day you file during the entire adjudication period of that initial petition, okay? And the reason you can sort of imagine a situation where if the immigration authority takes 2 years to process your case, and then your son is over 21 when the case is approved, that's not a very fair situation to say your child can't immigrate with you just because USCIS took so darn long to review your case. Okay, so the law says that the time the underlying petition was pending does not count towards the child's age. Okay, so that's sort of point number one. And again, that's if you have a child that's close to 21. You want to file that petition as soon as possible. Okay, with a looming wait list. Children above 20. We're getting into a situation where calculations and it's going to become dicey as to children that old and whether they can be included. So you want to file as soon as possible to get that to get that priority date locked in. Okay, the moment the petition is approved, okay. The moment the petition is approved, we look to the visa bulletin, okay, and we see if a visa is available. A visa is available pursuant to the visa bulletin and based on the final action date. And if you're in the U.S., okay, you can also file for adjustment of status based on the dates for filing, and you may be able to pay your fee bills and get your DS-260 started if you're abroad, okay. Once that petition is approved, your child continues to age naturally based on the age they were when we filed. So if we filed 2 years ago and your child was 19 and the case is approved 2 years later, from an immigration standpoint, your child is still 19 and their age continues to go, okay? We refreeze the age in 2 different situations, okay? If we're filing concurrently and we already got the adjustment of status in, we don't worry about a thing, okay? Because adjustment of status is one of the relevant mechanisms we use to seek to acquire the visa. And okay, there's a lot of legalese here, but adjustment of status freezes permanently. Okay, if you're in a situation, for example, where maybe you were abroad and you filed the 526E where you were abroad, okay, case is approved. Okay, we look to the visa bulletin. If you can start consular processing by paying those visa fee bills, okay, that refreezes the child's age at his immigrant age, okay, which would be 19 in our example, okay? And so at the end of the day, there's two things to think about. How old is your child before we file, okay? What is the likelihood a wait list is coming, okay? And how old is your child vis-a-vis, how long we think the wait list could be. If we can file now, and we can do adjustment of status now, that's going to lock in your child for the remainder of the petition, okay, for the entire immigration process. So again, if we look back to our conversations about adjustment of status, the work permit, the travel permit, the most important aspect of all of this, of getting the adjustment of status in for a family that has a child that is in high school, I would say in high school at this point in time, or maybe in college, okay, is locking in their child if they're from China or from India, because both those categories will face a wait list in the future, okay? So again, if you can file adjustment of status concurrently with your I-526C, you're going to keep your child as part of that entire, immigration process, irregardless if there's a wait list in the future. Okay, that's another super important point. Okay, the calculation, these issues can be a little tricky, especially when wait lists come into play. So again, definitely something to talk to your attorney about, and let them know early on in the process, how old your children are, whether you're abroad, whether if your children are abroad, for example, studying. There's a lot of nuances that come into play.
Perfect. All right, let's move on from that and just talk about some general considerations to keep in mind that could help reduce risk across each of these different visa categories from which you'd be adjusting status.
Yeah, sure. We touched on this a bit in one of the previous slides. Again, B2 visa, F1 visa, and again, I nothing here is immigration advice. I'm an immigration attorney. This is all information. You do want to talk to your immigration attorney if you're in the U.S. and B2 status, F1 status, even E2 status, and you just traveled and you want to adjust status. Okay, while it's doable, there are numerous considerations to consider, and the reason is the following: when you enter the U.S. on a tourist visa or a student visa, you arrive at the airport and you give the CPB officer your passport. They say, "What are you coming here to do? You're coming to visit. You're coming for business. I'm returning to go back to school." They stamp you, the passport, and they admit you. Okay. Your intent at that point in time is supposed to be temporary intent, right? Non-immigrant intent. I have the intent to stay temporarily, to visit for pleasure, to visit to do business, to study, and then return home. If you turn around very quickly and do something in the US, like marry a US citizen or file a green card petition very quickly, UCIS could make a discretionary finding and essentially state that you misrepresented your intent. Okay, you've committed a civil violation, and you've essentially lied to an officer saying that you were coming here temporarily because you really didn't mean to do that. Okay, now again, there are other issues to think about in terms of how long it's been since you were last admitted. Okay, and I'm not going to get into the nuances of the old 60 to 90-day rule because time can pass and your mind can change. Okay, but again, very important to talk to your attorney about whether it makes sense to file for adjustment of status, when to do that, and whether it may make sense to simply file the I-526E petition first, and perhaps apply for adjustment of status at a later date. Okay, the H-1B and L-1 visas, again, classic dual intent visas. You can file the I-526E concurrently with adjustment of status. Whenever you'd like, as long as you're physically here in the U.S. If you traveled back yesterday, we can do so tomorrow. Okay, and again, these are dual intent visas. The reason they're dual intent visas is because many of the visa holders frequently are looking to not only work in the U.S. temporarily, but also maybe working in the U.S. permanently for that employer. So that the whole process was created to allow employers to also sponsor their temporary workers permanently and not have it conflict with their underlying temporary visa. Okay.
All right, perfect. All right, now, even if you work closely with the most experienced EB-5 immigration attorney and submit, a quote, perfect application, USCIS can and still does make mistakes, right? So sometimes cases aren't available, sometimes documents aren't added to the right file, things need to be resent. So Dennis, can you talk a little bit about kind of your thoughts and just why it's critical to just work with an experienced immigration attorney to not only try to prepare an application that, doesn't have mistakes, but then also to quickly diagnose, if there's a problem that USCIS created, and then, quickly address that problem before, it manifests and festers into something, that can be, could be fatal.
Yeah, yeah, I mean, I think it, like anything, any service provider, it definitely benefits you to work with someone who's done this before. There's lots of great EB-5 attorneys out there, and so I can vouch for many of them. I think it really helps make the process a little, much more seamless if you're working with a good attorney, if you're working with a good team that knows not only how to file a case, but knows what USCIS wants, right? Adjudication trends change, document requirements change, policy changes, and that can, significantly affect the case that's being prepared, whether, we're preparing something 5 years ago or now. Things change. Second, to your point, USCIS makes tons of mistakes. They, whether it's USCIS, Department of State, Department of Labor, all the agencies that are involved in the immigration process make lots of mistakes. They're busy, and some agencies are underfunded. There's a lot of policy that goes into this. I'm looking at this case status is unavailable. That happens for all my clients, right? IOE receipt numbers, I-526E and I-526 receipt numbers are very frequently unavailable for a variety of technical issues that the government websites is having. Doesn't mean your case has gone awry, just means the website doesn't work. Okay, and this issue comes up all the time. If your attorney has filed numerous cases, they're going to know this and they're going to be able to tell you what the issue is. USCIS makes a lot of mistakes. Okay, they misplace files, they lose passport copies, they lose photos, they issue RFEs for documents that were already submitted. Sometimes they, will reject the case incorrectly, saying that your priority date isn't current because they've mistaken your EB-2 priority date for your I-526E priority date, and you have to refile and ask to not pay the fees again. Okay, there are numerous ways to contact USCIS. None of them are great in the sense that you're not going to get a very, you're not going to get an immediate answer. Even if you call and happen to get someone on the phone, sometimes the issue may have to be escalated to a supervisor. But there are numerous channels to get in touch with the various lockboxes and offices and push the government to do their job correctly. Okay, whether that's emailing the lockbox support, which I've had to do numerous times for cases that have been rejected incorrectly, lost checks, et cetera, et cetera. You could email your EB-5 attorney can email the investor program office directly to follow up on your EB-5 case, to let them know that you filed a supplement or an interfiling, to make sure they received it. So, the USCIS is far from perfect. I would say they're imperfect at best in many a situation. And so, having an experienced attorney that has, a good team, working with them that knows how to contact the government quickly, whether it's a simple status request or, or having, to do something, do a deeper dive. I think that's super helpful because these issues are going to come up. It's not your attorney's fault unless they, filed something incorrectly. The government makes mistakes, and so there's ways to tackle them, but you have to know what to do.
All right, perfect. All right, now let's shift gears and talk about some recent visa demand trends, and I can jump in on this first one. So over the last 10, 11 years, we've seen kind of a fluctuation in EB-5 visa demand. In 2014, to 2017, demand was increasing. We had a lot of applications coming in, and the investment amount was $500,000 compared to the $800,000 it is now for TEA projects. And then program lapsed, and then COVID happened, and volume, significantly dropped over the next few years. And then with the recent RAA program renewal in 2022, we can see the last couple of years volume has been steadily increasing, and that's definitely the trend that we're seeing in the market. And a large part of that is the priority, faster processing that we're seeing for rural TEA projects. Over the last 2 years, we've seen almost 200 rural TEA approvals in our rural projects. And what's really interesting here is that you can see this trend with, the more recently approved rural applications. You can see that the processing times are actually becoming more consistent. So, they're scattered around that trend line. And also, they're becoming faster. So a lot more of them in the more recent cases are below 10 months, a lot of them in the kind of 7 to 9 month window, and much more consistent. And so that's kind of, good information to know that as time has gone on since these new rules went into effect in 2022, the government, has trained its adjudicators, and they're becoming more efficient at approving applications, in a shorter period with higher volume. And so that's really important to note. And Dennis, I know you filed quite a few rural cases as well over the last couple of years. And yeah, what's your experience been with your clients, across a broad sampling of projects?
Yeah, it's a super helpful chart, and only especially just looking at the trend line, because I can definitely say that, say in late 22, most of 23, I was seeing rural cases approved, and I had a few cases approved in less than 2 months, and I had cases approved in 12 months. Okay, I haven't seen any that quick since late 23. But a vast majority of my cases that I filed, say late 23 throughout 2024, are now consistently being approved in, maybe 8 to 12 months. And the pattern that's sort of outlined in this chart is somewhat similar to what I'm seeing. You may have different situations where you have certain clients that that band together and maybe sue the government, file a mandamus suit to get their case approved in 6 months. Typically, you're not gonna see that happen before then, but I'm seeing much more consistency now, especially with the big batch of cases that went out February, March of last year before the fee increase, before the government fees increase. We're starting to see quite a few of those approved for rural cases.
Yep, got it. Okay, that makes sense. And then just in terms of total volume, we've seen an increase in rural applications compared to urban. Historically, through July of 2024 is about 60-40, but over the last 6 months, we've definitely seen a much greater shift toward rural, which is probably at or in excess of 50%. And obviously China, is the biggest, single country, followed by India, and then the rest of the world. So more interest in rural, obviously, given the priority processing and the greater visa set aside. And when we look at what category, urban or rural, we think is going to backlog first, when you look at how many applications are pending and then factor in how many family members, how many actual visas per $800,000 investment are going to be needed, it's pretty clear that there's a much larger shortage for urban high unemployment TEA visas that are available versus the level of demand. And so it's unclear whether that means that category will backlog first, although we believe that is clearly the case. It also has to do with how quickly applications are getting approved and how quickly visas are actually getting used up. But yeah, Dennis, what are your thoughts on kind of a potential backlog coming, and how does that look?
Yeah, I mean, this chart's great. I've seen this chart. I remember when you guys put this one out. I think there's been a couple other that have been published that have drawn pretty similar conclusions. And so I always tell my clients, there's math involved here, right? There's stringent numerical limitations. There's specific laws that dictate and policy that dictates how visas flow over and where visas go if they go unused. And then there's the unknown, right? There's petitions that are pending. We don't know how many, specifically how many family members are in each petition, whether some kids may age out, family members pass away, babies are born. Some people stop filing, some people withdraw. So there's a whole host of variables that inevitably sort of change what the final backlog's going to be. But yeah, I draw the same conclusions. I still think that you're going to have a longer wait list for high unemployment. I don't see a world where that isn't the case. I'm still seeing, a pretty strong majority of most of my clients from China and India looking at rural. But it's not 90, 95%. I have quite a few clients that are looking at high unemployment projects because they know they can file their adjustment of status. They can have that pending. They can get an EAD. They can get a travel permit, and they like the project. And obviously in this world where you're investing this much money, project selection is incredibly important. So, but yeah, these conclusions make sense to me. I think we're going to have to see when a cutoff date is issued, this fiscal year, which looks like it's going to be this fiscal year based on last month's visa bulletin, what exactly timing looks like. Okay.
Yep. And so with that, let's spend a few minutes and just talk about the visa bulletin. What is that? Why does it matter? And what can we take away from the recent language that we saw in the January visa bulletin for investors, considering EB-5?
Yeah. So the January visa bulletin sort of shook up the EB-5 world just the way it did, years ago for China in 2015 and India in years after that, in the sense that the Department of State has notes at the end of each visa bulletin where it offers somewhat helpful, predictive insight into the future in terms of visa usage and when it believes a cutoff date may become necessary based on, fiscal year available visas and current adjudication trends. Okay, so the January visa bulletin, it's right there in yellow. It may become necessary to establish dates for filing and final action dates during the fiscal year, right? So during the current fiscal year, which runs until October of 25. Okay, what it doesn't say is a few things. It doesn't say, which country is going to be subject to it. I think everyone knows it's going to be India and China. And it doesn't say whether it's high unemployment or rural or both. Okay, again, based on the previous slide, I think most attorneys and Department of State's officials, who have commented on this in the past, assume that high unemployment is going to backlog first. If they backlog at the same time, it's likely that high unemployment is going to have, a longer wait, right? A cutoff date that's further back in terms of years. We don't know exactly when this is going to be implemented. Based on conversations I've had with, numerous attorneys in the industry, if we see one in March, that would be very abrupt. In the past, we haven't had situations where, a warning's come out, we've had a silent February visa bulletin on this issue, and then backlogs issued. That would be rare. Okay, typically you'd have another visa bulletin that would have language that essentially says we anticipate, a cutoff date, a final action date being implemented for X, Y, and Z categories no later than a certain month. And in the past, when that's occurred, it's a few months after that warning, maybe 3 to 4 months afterwards. Okay, in previous iterations, years before, it's been May, June, July. I know some attorneys think that's what we're looking at. At the end of the day, we don't know. Okay, and so it's if you're in a position where this is something you want to do, you want to file before, you want to file in February, right? Because February is current. We'll know if March is current, hopefully a few weeks into February when the new bulletin's released. But based on what I've seen in the past, that's essentially what I can say. It's there's a lot that goes into this. USCIS has to keep approving adjustments and issuing the green cards. Consular officials have to approve cases abroad and and stamp that immigrant visa and pull for the quota to go for visas to be pulled from the quota. So until these very specific adjudication actions are taken, that visa number doesn't go down for the fiscal year. Okay, and so we're seeing adjudications now. I know everyone's seeing adjustments approved. So, we're going to have to see what the next couple of visa bulletins have to say.
All right, and this is not an isolated incident. We have seen this same warning language appear a few times historically. So yeah, let's talk for a minute about that and kind of what we've seen in the past.
Yeah, I I didn't know the slide was coming. This is exactly what I was talking about. So this is great. Yeah. So again, the 1 to 3 months is what we've seen in the past. Now that's helpful. Government tends to do, act similarly. The visa bulletin's very important because, and the reason it's published is to give attorneys, to give petitioners a heads up about what's going on. It's to facilitate not only the knowledge of when things are happening and when you can file, but to plan. And so it does no one any good to have an abrupt change from current to backlog. Could it happen? Of course. But what we've seen in the past with these sort of historic visa bulletins that have been issued are typically a 3-month lag, right? So you have a warning in back in 2015 we had that warning in February, we had a cutoff date in May. Similar situation 2017 and 2018, and we had a very quick one in 2019. That's more of a unique situation. I think for India we assumed that was going to happen, but end of the day, could we see a backlog in March? Of course. I think a lot of attorneys think it's more likely than not closer to the summer months, which is when backlogs tend to happen more frequently, as the fiscal year nears an end. But this is what we've seen in the past. It's helpful to acknowledge, but it's definitely not it's not going to confirm whether or not we see something March, April, or May.
All right. And so let's talk a little bit about the mechanics. So let's say the visa bulletin's current now, but then what happens in the future when there is a cutoff date announced, and investors still want to try and jump in before the door closes and still be able to adjust status. What does that process look like?
Yeah, so it's a good point. Any attorneys who've done this a while knows that you often get predictive information from a previous month's visa or a current month's visa bulletin lets you know when a cutoff date is coming, and then you're very busy for the rest of the month because people want to file their adjustment of status when the priority date is current. So again, in your example, if you have you have a cutoff date in March that's published in February, right? You're going to need to file your concurrent I-526E and adjustment of status application in February, okay? Because again, your priority date is when you file that I-526. It's the day after you file, assuming you filed overnight, okay? And so if there's a cutoff date in March, you're going to be subject to it for the most part, okay? You need to get your adjustment of status in the month where the visa bulletin is current. So in your example, that would be February. Points to consider are the following, especially because recently USCIS has mandated or essentially stated that medical exams shall be included. They need to be included with the adjustment of status filing, or else they may reject the adjustment of status filing. That wasn't always the case. You could file the adjustment of status and submit the medical exam later, even wait till a request for evidence came. It doesn't always take a week to get these exams. There's vaccinations that are required. Some doctors' offices in certain cities, have longer wait times. And so, it's definitely something you want to consider. If you're going to do adjustment of status, you want to submit that medical exam. And again, if you file when it's current and your case gets rejected because there's a mistake in the form or you didn't include your medical exam, it's very unlikely that you're going to get to file when it's not current. You could try to you could try to plead your case and see if you could refile, but that case needs to be well prepared, and it needs to be acceptable, receivable when you file it.
Got it. And again, just another reason why when you've got that kind of a cliff, it's critical to work with somebody who knows what they're doing, so you don't have a clerical error or mistake and then completely miss out on one of the major benefits of getting the EAD and the AP as part of your application.
And what I will also say is just generally, if the visa bulletin isn't current, you can file your I-526E. That'll start your clock, but you have to wait until that visa bulletin's current from the dates of filing, okay, at a minimum, in order to get the adjustment of status in, as well as the work and travel permit. Okay.
Yep, exactly. All right, so we'll shift gears. I'll spend just a few minutes chatting about a couple of our currently open rural and urban projects, and then we'll wrap up. So as we discussed, right now the trend is toward the rural projects. They're definitely a little bit more popular given the greater allocation of visas, 20%, and the faster priority processing, which we're seeing, translate into approval times of 7 to 9 months, which is really, really quick. So on the rural side, we have 2 different rural projects currently open. Our Rocky River project, which we need to update this. We actually just got the Form I-956F approval yesterday. That's a rural project outside of Charlotte. It's a large master plan community already under construction with a huge job cushion being developed by the Coulter Group, one of the largest private developers that we've done over 25 EB-5 projects with a perfect track record. And then our Tamarack Resort, also a Form I-956F approved rural project, master plan community with ski, golf, and lake access out in Idaho, with over 2,000 jobs already created. So all the jobs already in place for all the investors. And then on the urban side, our Boynton Beach multifamily equity project, also like Rocky River, being developed by Coulter with a 5% annual preferred return and a shorter investment period. And then our One Tampa loan project, also being developed by Coulter with Form I-956 approval in place, hundreds of jobs already created, and really strong sales and a shorter investment period. In general, the urban projects will have a shorter duration of investment, but you're waiting longer for the green card, whereas the rural projects, you're getting the green card faster, but you're typically looking at a longer investment period. So you just really have to decide, what the priority is. Is it getting the green card faster, or is it getting the money back faster? And that decision will really kind of drive, your preference, as well as your ability to adjust status. If you're in the U.S. already and you can get most of the benefits of working and traveling freely with a work and travel permit, then you probably don't need to do the rural, because you'll get that with the urban project, and you'll be able to get your money back faster with the urban project. So that may be the better fit. But again, got to kind of pros and cons to everything, and really discuss that with your family and with your immigration attorney as to what's going to be the best fit given your personal situation and investment, financial picture as well. All right, well, that kind of concludes the formal remarks we had for today. I think, Dennis, it'd be helpful if you kind of spend a few minutes and discuss, how do clients reach out to you, get in touch, and also work with you? What does your engagement process look like? How do you work closely with clients in different time zones, different languages, to make sure applications can get put together quickly and filed, with upcoming deadlines? And everyone wants it done, yesterday. So how do you kind of work with the clients and your team to go through that source of funds process?
Yeah, sure. So that's my contact information below. Email is generally best in terms of, asking if you want to have an initial consult with me. You can also fill out the contact form on my website. Once we start working together, I have a small, robust team, 4 paralegals that work with me, a few attorneys. I've trained them all myself, so we do EB-5 day in and day out. Generally speaking, we work through various communication, methods. We do email. We'll have a joint WhatsApp group if that's helpful for quick questions. Secure Dropbox for uploading documents and reviewing them. And we always aim to file as quickly and as efficiently as possible. Obviously, every case is different. We never want to rush. We want to make sure the case is accurate and provable before we file. But we're taking on new clients. We're busy and happy to hop on an initial call. Just feel free to reach out. We can schedule something to discuss your situation and whether we can help.
And what obviously there's many EB-5 immigration attorneys out there. What do you think? Having been in this space for a while and interacted with a lot of other firms and attorneys, what do you think kind of sets you and your team apart, from some of the other out there? Why would someone want to hire you, or should hire you, versus some of the others?
Oh gosh, there's a lot of good attorneys out there. I have just tons of respect for so many colleagues in the industry. Let's see. We're a small firm. The goal is to provide intimate service. You're going to have contact with me whenever you'd like. Obviously, I can't pick up the phone every minute, but I like to be available. We respond in 24 hours to all communications. We aim to respond. Aim to review documents. 48 to 72 hours after all of them are submitted. We offer various modes of communication, which I think is helpful. I don't think we need a formal email every time you need to ask if a certain document's required, which is why chat groups are helpful. So I think I've worked at different firms before. There's all sorts of different types of firms out there that have different levels of communication, different processes. We have something that's repeatable. You're always going to work with me. You're going to have a paralegal that's going to work with myself on the case. The goal is to prepare the case accurately and for you to be able to communicate with us whenever you need to. That's the reason I started my firm 4 years ago is to provide good service, compassionate service, but accurate service. So I guess that's what I'd have to say. Thanks, Sam.
All right, awesome. Thank you, Dennis. And our team, has seen many of our clients use Dennis and his firm, and he has our strongest recommendation. And he's also fluent in Spanish as well, so he can
I am, yes.
directly communicate in Spanish with any Latin American clients as well. So awesome. Thank you very much, Dennis, for taking the time. We really appreciate it. Any investors who are interested in any of the projects we talked about, please reach out to us. You can scan that code, schedule a call, or send us a message. And anything related to the immigration process, adjusting status, please reach out to Dennis and he'll be able to help point you in the right direction.
Appreciate it. Thanks for having me on, Sam. Thanks, everybody.